Hello, my name is Kate Buhr, and I am excited to present my landmark court case of Donald L. Seemuller versus the Fairfax County School Board. My intentions for this presentation are to cover the case background, the legal issue, and court decisions that were made, the specific impacts of those court decisions on myself and my colleagues as teachers, as well as share my opinion about the case. I want to start with a little bit of background. In December of 1987, Lake Braddock's school newspaper, the Fairfax, was published an anonymous letter to the editor written by students that was captioned, "Angered Girls Fight PE or Physical Education Discrimination." Seemuller was a PE teacher at Lake Braddock School, and he responded to this complaint by submitting his own letter to the newspaper. The letter, according to Seemuller, was intended to be satirical. Before its publication, the paper's faculty advisor and the principal read the letter. Neither objected to its publication or asked Seemuller to withdraw it. The principal did not warn Seemuller that publication would lead to disciplinary action. The principal did not speak to Seemuller about the letter until after it was published. So now, the letter. Seemuller wrote the following: "I cannot speak for every member of the staff, but as for myself, I like girls and the many things they can accomplish. My two females at home are a 16-year-old whom I permit to chauffeur my son to and from his many activities, and my wife, who is an adequate cook and housekeeper. My wife also does light yard work, enabling me to play golf and pursue many other masculine activities. Hopefully, this letter will convince those girls in physical education at Lake Braddock that we have the utmost respect for their feminine talents." A little bit more about the case background. So, Donald L. Seemuller's pay was frozen due to a poor teacher performance rating given to him by his principal as a result of submitting that satirical letter to the newspaper. In response to his pay being frozen, Donald Seemuller brought a $350,000 lawsuit to the Fairfax County School Board. That case, he argued in that case that he was being punished for exercising his First Amendment right to free speech. The U.S. District Judge Claude M. Hilton dismissed the case after a day of testimony, saying that what Seemuller wrote was not a matter of public concern and therefore did not meet the requirement for First Amendment protection. Seemuller, supported by the Fairfax County Federation of Teachers, appealed that verdict on the sole issue of whether Seemuller's letter addressed a matter of public concern. So we are going to look more specifically at the First Amendment right protection for teachers and what does matter of public concern entail. So those two legal issues are in consideration when we think about, again, Seemuller was arguing that he was being punished by his pay being frozen for exercising his First Amendment right to free speech. The Fairfax County School Board, on the other hand, said the letter spurred dozens of complaints and showed a lack of mature professional judgment. We know that the First Amendment protects speech that enhances the public's ability to make informed decisions. So that's the matter of public concern caveat. Public employees who, by virtue of their employment, possess information that may enhance public's knowledge cannot be dismissed for disseminating that information. And we also know that a public employee's right to speak is not absolute. So, the threshold consideration for public employees seeking to invoke First Amendment protection is whether their speech, or in this case, Seemuller's letter to the school newspaper, concerns some issue that is of interest to the public. Once the employee's speech has been determined to relate to a matter of public concern, that employee's right must be determined by balancing the employee's interest in commenting on this matter of public concern against the employer's interest in providing efficient public service. I want to take a look at the verdicts. As a reminder, the first case was dismissed by a judge after a day of testimony. For the appeal ruled in favor of Seemuller. They protected Seemuller's First Amendment rights because the letter dealt with a matter of public concern. That was the verdict, that letter did in fact deal with a matter of public concern. They stated that the record discloses that even before the anonymous student letter was published, some girls had complained that they were treated as second-class citizens in the school. The exchange and correspondence between the anonymous letter writers and Seemuller sparked much livelier discussion about discrimination based on sex. The day after Seemuller's letter was published, the principal met with 32 girls regarding discrimination and assured them he would not tolerate it. Later, the school Human Relations Committee met and urged the principal to take steps to prevent discrimination based on sex. Some people, taking Seemuller's letter literally, were offended by it and criticized it as demeaning toward women. Nevertheless, the fact that some persons considered the letter to be inappropriate or controversial is irrelevant to the question of whether this letter deals with a matter of public concern. The public expression of ideas may not be prohibited merely because the ideas are themselves offensive to some of the hearers, was the declaration of the judge. Seemuller's use of satire to comment on a matter of public concern did not deprive him of the protection afforded to him by the First Amendment. And I really now think that we explain public concern and our First Amendment rights as educators, we can get into the impact that this case has on teachers. The conclusion was that a complaint published in a school newspaper that a public school discriminates on the basis of sex does indeed raise a question of public concern. Therefore, Seemuller's published response to that complaint is protected by his First Amendment right. A case that does provide some additional background to the ruling of Seemuller versus the Board of Fairfax County is Pickering versus the Board of Education, 20 years before Seemuller's case. This case's background was that Pickering was fired after writing a letter to the town newspaper criticizing the Board of Education. The Circuit Court and the Supreme Court of Illinois affirmed Pickering's dismissal, but the U.S. Supreme Court reversed the previous decisions. This case established the principle that public employees do not relinquish their right to speak out on public matters simply because they are public employees. So as we can see here, this case greatly impacted the appeal decision in Seemuller versus the Fairfax County School Board. My opinion was super tough to land on. It took quite a bit of research. My initial opinion was that Seemuller was completely wrong, should not have did what he did, had every right to receive the lower principal rating, which caused his pay to freeze. But that's not what the case was looking at. And so, should he have written the letter? No. But did he have a right to publish that letter and have that letter published? Yes. So I agree that because it was a matter of public concern and there was no censorship, no warning, no feedback from either neither the school newspaper editor, so a colleague of Seemuller's, nor the principal, that he had every right to have that letter published. And the letter was a matter of public concern. Therefore, his right to have his pay protected by writing that letter is correct. So I agree with the court's appeal decision. And how this impacts myself and my colleagues as teachers, I think it really helps me look at understanding my own district's policy around the First Amendment and my protections from that as an educator, and to really dig deeper into my union involvement with curiosity. There's so much I don't understand about our contract, the language of our contract, and my protections of that contract. And so um, I have heard time and time again of how careful we need to be as educators. And I also um, proceed fully with caution, but I'm also curious what our rights are as educators. So those are the impacts on myself and my colleagues. And here is a list of my resources. Thank you all so much for listening, and I hope you have a great rest of your day.